Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Today's topic is going to be about who can use New Jersey's probate waiver form L-9. But before we dive into that topic, if you have any questions pertaining to estate planning or probate, please contact me at njestateattorney.com. You can send me an email directly at david@campanilelaw.com, or above or below, there's a link to my schedule, my calendar. You can schedule directly there. This is a free consultation. So, who can use New Jersey probate waiver form L-9? This form is for real estate purposes only. So, in previous videos, we've done the L4 and L8 forms. So today we're focusing on the L9 form. So the executor, the administrator, or the joint tenant of the property can fill out this form. Now, you're only eligible for this form if you're a Class A beneficiary. We've gone over that multiple times, but just as a refresher, Class A beneficiaries are going to be either a spouse or a civil union partner, your child, which also would include legally adopted children, grandchildren, great-grandchildren, parent or grandparent, a stepchild, but remember, not step-grandchild, and a domestic partner. And the domestic partnership had to be established on or after July 10th of 2004. However, you may not use the L9 form if any of the following conditions exist. And for the first one, it's going to be on the deed. The real estate was held as tenants by the entirety, jointly by spouse/civil union partner, and the spouse or civil union partner is surviving. Any asset of the decedent valued at $500 or more passes to any beneficiary other than a Class A beneficiary, which was named up top, which I just mentioned to you. The relationship of a mutually acknowledged child is claimed to exist. This one is a little difficult, but you both acknowledge that a child is there, and wow, it's really difficult to explain how that one works. And then when there is any New Jersey inheritance tax or estate tax due. In New Jersey, there is no estate tax due. This waiver, since it's Class A beneficiaries, there wouldn't be an inheritance tax due either. Just a reminder, if there is a trust that exists, that was created, or if there is a trust that was created in the will, they may require you to file a full return if that trust document says that there indicates any possibility of an inheritance tax. So what do you need to attach to this form? You're going to need a copy of the will. If there's you're going to need a copy of the deed for each property. You're going to need your letters of testamentary or letters of administration, and you're going to need a copy of the death certificate. This is going to be mailed to the Division of Taxation. Now, this form is it is a self-explanatory form. I will say New Jersey has done a very good job of making these forms very simple to fill out and straightforward. So what you're going to do is you're going to list the beneficiaries, you're going to list the relationships to the decedent, and you're going to state what their interest is. Is it 100% interest in the property? Is it the property being split? Are there certain percentages? Then if anybody has predeceased that would have been a beneficiary to the decedent, you're going to list their names, their date of death, and where they resided at the time of death. Just put the county and state. And then what you're going to do on the last page is there are 3 boxes where you could give a description of the New Jersey real estate. Now, you're going to give, and all this information can be found on the deed. If you don't have a copy you're going to need a copy of the deed. So if you don't have a physical copy of the deed, you're going to have to go to the county clerk's office or the county clerk land record in the county that the property resides in. You're going to have to either search for the name or physically go there, give the name, and ask for an original deed, they will be able to provide that to you. So what you're going to give here is you're going to give the county the property is located in. You're going to give the street and the number of the address. You're also going to give the lot and block number, and you're going to give the municipality, and you're going to write who the owner is. And you would write, for example, the owner of record would be, for my property, it would be David Campanile and spouse, as husband and wife. So that's how, and being that we have a 50-50 share in the property. And you have room for 3 of these, but if there are more properties, you can attach more of these forms. And just remember, you're also going to need, and we've gone over this, but just as a reminder, you're going to need to attach the copy of the will. You're going to need to attach a copy of each deed for the property, your letters testamentary or letters of administration, and a copy of the decedent's death certificate. I hope you found this video helpful in completing your L-9 form. If you did, please hit the like button. If you know somebody who may be going through the probate process and needs help filling out these forms, please share this video with them. Tell them you were thinking about them. If you have a question about this topic or any other topics in estate planning or probate, please do not hesitate to contact me for your free consultation at njestateattorney.com. You can send me an email directly at david@campanilelaw.com, or you can schedule directly at my calendar link, which is provided above or below. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.